Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. In view of the above details of the case, the following would emerge for consideration. Whether fresh lease deed has been executed by the lesser Dr. Manjula in favor of the lessee Messrs. Raja Info Limited, if so, to what period? Whether the lease agreement is required to be registered under the provisions of the Indian Registration Act 1908, whether the correction of flat number 608 in the true copy of the will is genuine and correct one or clause 7 of the will flat number 606 has only been mentioned, whether the will dated 1910-2004 executed by Dr. Manjula in favor of Dr. Baldev can be treated as will executed by Dr. Manjula. In other words, whether this document can be treated as valid will, whether the general power of attorney is required to be registered in view of existence of clauses 4 and 5. With regard to item number 1 above, it is advised that Messrs. Raja Info Limited may verify from their records whether a fresh lease agreement has been executed between the parties. With regard to point number 2 above, it is to state that in terms of section 17(1)(b) of the Indian Registration Act 1908, other non-testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property are required to be compulsorily registered. The words used in this subsection are non-testamentary, and the said words are used to refer those documents which are intended to be operative with immediate effect and to be final and irrevocable. The Clause B of Section 17(1) of Indian Registration Act 1908 provides that all non-testamentary instruments other than those of gifts must be registered if they purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, to or in immovable property of the value of 100 rupees and upwards. In this connection, it is stated that in this case the document referred to is lease, and hence it is stated that the word lease be used in the same sense as defined in section 105 of the Transfer of Property Act, and it may be noted that the lease of immovable property from year to year or for any time exceeding 1 year be compulsorily registrable, whatever may be in the value of interest created thereby. In this case, as the initial period of lease is for 3 years, extendable for another period of 3 years, the lease agreement executed initially on 11/8/1996 be compulsorily registrable document. So it is necessary to verify whether the lease agreement be registered or not. It may also be verified whether the lease agreement has been registered or not.